Welcome to NYSAC TV. I'm here with Stephen Acquario, the Executive Director of the New York State Association of Counties, and we're here to talk about a recent Supreme Court decision about prayer in government meetings. Why was this case important to local governments across the U.S. and in New York State, Steve?
Well, we're in the beginning of May of 2014, and we've learned from the country's high court that prayer, which is typically or often used in governments and state capitals, in the United States Congress, and in our world where we work in local government, county government, legislative chambers, we've learned today that prayer, in fact, can be used. In other words, a board can open up a meeting with a prayer used to set the tone often of the meeting for the important decisions that people who are elected by the public at large are given a great deal of responsibility to act on our collective behalf. So oftentimes government bodies will sort of set the tone or the mood of the gravity of the situation, reminding the lawmakers of the importance of the decisions that they make.
What was unique with this case? Why did the court hear it? Don't we already have precedent?
That's right. We do have precedents in the United States, precedent, if you will, with other court decisions that have come up, in particular in the 1980s, where the High Court ruled that the Nebraska state legislature is in fact authorized to use prayer to start the legislative session of the day. This case was important because it was a little different. In Nebraska, the court looked at the state's practice of sort of non-denominational or non-sectarian language that was used in a prayer, referring perhaps to a God, not necessarily the Son of God. The difference in this court case, coming from New York State, from a town of Greece in western New York, in Monroe County, New York, here it was more sectarian. The town itself, the prayers that were used, the chaplains that offered these prayers typically referred to Jesus Christ. It referred to the Son of God, the Holy Spirit, and there was a challenge by two women in this community who were very offended by that. As citizens of this town, attending a town meeting, a public meeting, a government meeting, those references truly offended them. So it was unique. This case was different than the court facts in Nebraska, and now we have a new law for the United States.
What laws govern this issue?
Well, religion itself is reserved by our founding fathers in the 1700s when our Constitution was framed. The very first amendment to the Constitution is the First Amendment, and it dealt with the freedom of speech. It dealt with the freedom of assembly, freedom of association. That's why the Association of Counties is legally allowed to exist. We're free to associate with whomever we choose. So too in religion, the founders strongly believed that the freedom of religion was that important, that the states could not establish a state-sponsored religion, in this particular case a town-sponsored religion, but the framers of the Constitution really felt very strongly that freedom of religion, tolerance, religious tolerance was part of our fabric.
What should local governments and counties take away from this decision today, Steve?
Well, that's a good question. I think the takeaways from this case is how you are structuring your prayer in government meetings. Whether you're a state legislature or a town or a county legislative body, the court made it clear here that prayer should be offered at the beginning of a session, a government meeting, a public institution, and that it should be used to frame the setting, remind the lawmakers themselves of the important decisions that they're making. We should remember that governments cannot influence a particular religion over another religion, and that's not the function of government. The function of government is to act in the public's best interest. If prayer is used, it should be used simply to set the tone and not be discussed or used in policy-making meetings. And that was a clear distinction here, that it was offered at the beginning. The fact that it was mostly Christian in origin or Christian-based, the court said that it did not need to look outside of the town boundaries to bring in a chaplain. So that was another takeaway of this case, that a county or a town need only look in their jurisdiction for chaplains to come in.
Great. Thank you for breaking down this decision. It's there's a lot more in it than meets the eye. Are there any other interesting facts from today's decision, Steve?
Well, I think that the fact that the High Court took up this case was very difficult for the court to address. Religion, government goes back to the beginning of time. It was part of who we've been for thousands of years. For the court to make this decision, I think, was very helpful to local governments, to state governments, as often they are using prayer to open meetings. So very important there. The other observation I would make is that the dissent, if you will, it was a 5-4 decision. So it was a close call. And the dissent, two of the judges were appointees of President Obama, who the administration sided with the town government. So here we're seeing as a society here how government best works, the separation of the judiciary from the executive branch, and I think that the outcome of this decision will be very helpful to governments for some time to come.
Thanks. And thanks for joining us today on NYSAC TV.